In today's video, I want us to go over the struggling heads of arguments by the state and why the state realized, you know what? We didn't do quite well in our heads of arguments. They're really struggling. So let's turn to our struggle evidence and find a way to bring in evidence that was not disclosed during the time when we had the litis dominus. That's right. Here goes my Latin. Okay. While we still had the litis dominus of the case, where we could call anyone, we could call any witness, we could do anything, we could hinder the defense. We could have even kept going on and on with calling witnesses for the next 5 years because we are the state, okay? The dominus litis belongs to the state. And no, we didn't take advantage of that. Advocate Zithulele Nxumalo, okay, Uzwide Galanga, Undo Andre went ahead and did a phenomenal, I repeat, okay, a phenomenal heads of argument application for Section 174 for accused number 4. Mapisa. Somebody wrote in the comment section that I'm backtracking. Okay, I'm backtracking like BALOYI. I'm now changing my mind. I had said Nxumalo did not do a good job. No. One thing about me, the good news is everything I say is on video. Okay, you can go back and rewatch it. I never said he didn't do a good job. And I quote myself, I said he did a great job. The only feedback, I even use the word feedback. The only feedback I would give him is that I would have preferred that he presented his heads of arguments as opposed to reading them. However, I'm going to grant him grace on that. So it wasn't like a total fail. I didn't fail him. I will grant him grace on that because we know it was an unpaid preparation time. Imagine he was unpaid and that's how great he did. And also he only had a week to prepare. So he didn't really have time to, memorize, okay, and translate all that he has written into presentation style. He didn't have that. Legal aid said, we don't care, okay, we're not paying for nothing, okay? And I think he did the best that he did. So I'm echoing myself again. That's what I said. If you heard me, drop a 1 in the comment section. Because one thing about me, if you think I said he did a terrible job, sure, no problem. Quote the minute and the video in the comment section down below. And I always read an apology. But you know what? I know what I said. Okay? And I said what I said. But let's continue on, okay? So this video, let's watch the struggle. Yeah, let's watch the struggle. And struggle it is, okay? This is Advocate George BALOYI, state, who, by the way, was paid, okay, during the time. Anytime the court is not in session, he is paid. He is not like the legal aid and done defense team. No, he is paid by you and me, of course, the state. Let's get into it.
But my lord, coming back to the heads on page 4,
yes.
Paragraph 4, 4.1, we mentioned that about 60 witnesses testified for the state and that their evidence can broadly be classified in the following categories. 4.1.1, the people who were in the house when the incident happened. 4.1.2, the neighbors of the Kumalos, Mr. Kangashe and Ms. Itabise Mukiti. 4.1.3, the police officers who attended the scene, Sergeant Tetwa and Matebula. 4.1.4, the forensic field officers, and here, my lord, we refer to Sergeant Musia and Lieutenant Colonel Mhlahlo. 4.1.5, ballistic evidence, and here we refer to the evidence of Lieutenant Colonel Mangena, Lieutenant Colonel Sireo, Warren Santini, Grobler, and Rulofse. We refer to 4.1.6 DNA evidence. Here we refer in particular to Captain Masetla. 4.1.7, we refer to the confessions of accused 1 and 2. The pointings out of accused number 1. And Also the evidence of the investigating team, Brigadier Gininda, Sergeant Mohola, Mohane, etc. Then 4.7.8, we refer to the corroborating evidence. And here, my lord, we refer to the evidence of Mr. Lionel Zwane. We refer to the documentation from the Legal Practice Council regarding Mr. Mjiyako. Then 4.1.9, we refer to cell phone evidence. And here, my lord, we refer to the evidence of Colonel Stein, Colonel House, Ms. Pinky Faithillingham. In paragraph 5, we deal with the summary of the state evidence. My colleague, Dr. Sibanda, will take the court through the summary of evidence. If I can ask the court to turn to page 15, it's paragraph 6.
Page 15?
Yes, page 15.
Yeah.
Page 15, paragraph 6. There, my lord, we deal with the purpose. Section 174. I think what we need to mention at the outset is that whatever ruling the court makes is that it's an interim ruling, my lord.
What an incredible statement by Advocate George BALOYI, okay, the author of the struggling evidence. First of all, he goes through the list of witnesses as if we already don't know who they are, okay, as if that is important. Such a long intro, okay, just for him to tell the judge, okay, that whatever you decide on whatever Advocate Ngumalo has applied for in the section 174, I'm here as the state advocate to remind you that it is an interim decision. Oh my goodness, BALOYI. He was already found shaking because, I repeat, if you haven't already heard me say it already, Ngumalo actually did a phenomenal job. I think he came out of the woodworks, or Advocate George BALOYI had low expectations of him or undermined him. But when he got a hand of that application, he must have said, damn, this is damn good. This is pretty damn good. So we're going to invoke cooking methods here. Let's continue on. The other thing I wanted to highlight is he lists everybody who were the witnesses. So he will say the cell phone evidence, and then he'll list by Coles, Stain, and Pinky Van Dyke. He will list. The only people he didn't list, guess which ones? Those who were in the house. He doesn't list those who were in the house. And I believe that's strategic, because if he listed, it was going to be crystal clear that, wait, some people were not called, especially since they were the complainants. Exactly what Advocate Ngumalo said in his heads of arguments, that Kelly Kumalo and Gladness Kumalo are the complainants, okay? But they are nowhere. They've never, ever made it as a guest of the state into the witness box, which is quite diabolic. Let's continue listening on.
If the application is refused, there will still be a final ruling at the end of the case. Paragraph 6.1, we refer to the work of the renowned author, career on Himstra criminal procedure, the 2008 edition. At pages 22 to 76 describes the purpose of section 174 as follows, and we quote, Section 174 creates an exception to the normal trial procedure, primarily to relieve the trial court of the burden of persisting machine-like with a futile trial when it is clear that there cannot be a conviction. The purpose is to save time and effort and not to complicate the court's task. There are jurisdictional prerequisites to be satisfied before the power arises in this manner. The court must be of the view that there is no evidence upon which a conviction can be based. Therefore, two related but distinguishable decisions have to be made. Firstly, is there lack of evidence? And if so, should discharge be granted. The former entails mainly a clinical assessment of the evidential value of the evidence. The latter requires sound judgment in the light of all the circumstances of the particular case. I don't know if Mr. Jonas would like to interpret this to go along, or must we first finish? Finished. Okay, thank you. Paragraph 6.2. In S versus Agliotti, 2011, volume 2, SACR 437, is a decision of the South Gauteng High Court at 456, paragraph 271. The court held as follows, and we quote, in terms of section 174, there is no obligation to discharge, but a competence to do so. The court is called upon to act judicially with a sound judgment in the interest of justice. The facts and circumstances of each case dictate the route to follow. In paragraph 7, we deal with the test for application for discharge. Paragraph 7.1. Section 174 of the Criminal Procedure Act 51 of 1977 governs the test to be applied when there is an application for discharge of the accused at the end of the state case, and provides as follows, and we quote, if at the close of the case for the prosecution at any trial, the court thinks that there is no evidence that the accused committed the offense referred to in the charge, or any offense of which he may be convicted on the charge, it may return a verdict of not guilty, and we close the quotations. In paragraph 7.2, it is tried law that the words no evidence do not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. Then paragraph 7.3, whether or not to refuse or grant a discharge at this stage of the trial entails the exercise of a discretion by the trial court, and the refusal to discharge an accused at the close of the prosecution cannot be the subject of the appeal. This once more might just demonstrate the wide discretion that the court has at this point in time. And we refer to the case that my learned colleague also referred to of State versus Lubata, 2001, to SACR 703, and it is a decision of the SCA.
Yeah, that's it. I'm thinking, well, obviously, different cases, different facts will apply. But in this case, I made 3 rulings. One in terms of the so-called confession of Mr. number 1, and another in respect of the Mr. number 2, and the pointing out, remember?
Yes.
And those are interim judgments.
Yes.
Are you with me?
Yes, ma'am.
I haven't heard the version, the material version on the merits. Am I correct, or I'm just a met?
Yes, well, it is indeed so, ma'am.
Yeah.
And that is the point that we want to buttress, that there's no evidence under oath at this point from, as far as the merits are concerned.
That's correct.
From any of the accused.
It's different if, in my mind, it's different if I've made a ruling already, a final ruling,
Yes.
concerning those confessions and the pointing out. But here, they are hanging in the air.
Indeed, my lord. And
Okay, fine, you hear me.
if we were at the end of this state case, it would have been a different kettle of fish, my lord.
Okay.
And paragraph 7.3, the test is well known, one of inquiring whether there is evidence which, if believed, a reasonable person might convict. And we refer further to the work of Detoy on commentary on Criminal Procedure Act, pages 22 to 121. The court held as follows in the SCA in Lubata's case, and we quote, clearly a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation at some stage he might incriminate himself. That is recognized by the common law principle that there should be reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated, and the constitutional protection afforded to dignity and personal freedom. These are the passages that my learned friend referred to yesterday, Section 10 and 12 of the Constitution. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold, and that will preeminently be so where the prosecution has exhausted the evidence and a conviction is no longer possible except by self-incrimination, and we have bolded those portions. A fair trial will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12. The same considerations do not necessarily arise. However, where the prosecution's case against one accused might be supplemented by the evidence of a co-accused, and we've bolded that portion, the prosecution is ordinarily entitled to rely upon the evidence of an accomplice, and it is not self-evident why it should necessarily be precluded from doing so merely because it has chosen to prosecute more than one person jointly. The accused are charged on the basis of conspiracy, and the application for discharge ought to be refused on this basis as well. Then in paragraph 7.4, we refer to the case of...
As you can hear, Advocate Baloyi struggled with making any point that we can resonate with. Literally, I'm just sitting here and waiting like, okay, get to the point, get to the point, get to the point. And then he still continues to push on, well, the confessions which are interim. Therefore, since they're interim, how can you make a final decision on accused number 4? Yeah. Let me know your predictions. Let me know your predictions on if accused number 4 is going to be granted this Section 174 Dun. But who is that seated behind Advocate Baloyi? Is that Mr. Lapoye? Let me know in the comment section down below. And of course, I'll catch you on my next upload. Bye.